So today we're going to be talking about motions in limine, what effective motions in limine look like, strategy behind them, etc. Judge will ask your opinion at times too, but first, why don't you talk a little bit about your practice, Brian, so people can get to know you.
Sure. We are a plaintiff's personal injury practice, primarily based out of Philadelphia, but we are both heavily concentrated in Pennsylvania and New Jersey. We have a full gamut of types of claims that we handle, but most are the catastrophic injuries that we find resulting from workplace accidents in the third-party setting, and where we step in and try to provide people help and answers and get them through the rest of their lives, or provide for the family members that are left behind as a result of an accident. That's what we do, and we've been doing it for a number of years. We've been growing. We started the firm about 5 years ago, and it's been going well.
Great. And if you get a chance to talk to Brian, he's plaintiff side, so obviously most of what I do is on the defense side. But we had some pretty interesting conversations last night. It was very useful information to me to get some insight into how he approaches early case resolution, that kind of thing. It was really pretty engaging. We had a pretty good time at the party talking.
We did. Thank you.
So anyway, we're talking about motions in limine. So from your perspective, when do you first start considering what your motion in limine are going to look like?
Sure. Our practice, the motions in limine, we almost have to start considering at the outset of the case, when we first start interviewing the client and start putting the case together and thinking about the case. Mainly because of the fact that who are we relying upon? We're relying upon the client for our proofs. Is that client vulnerable? Criminal records or criminal history? Or whether or not wage loss or other things are going to be a huge component. Are they vulnerable because of a drug history or some employability issues? So these are all things when we're measuring case value, because ultimately we are operating a business as well. Now, if we're dealing with a client who's deceased, how are we going to put the case together as to meet our burdens? And in certain cases, where if it's a toxic exposure such as to benzene, where you have to go through and you have to have varying levels of experts, almost 5 levels, where they each have to build on one another, the amounts that you're talking about to litigate that case are prodigious. And if you start having holes in any of that because you're not able to establish the necessary proofs, then you're going to take a bath and you're going to be vulnerable at the time of trial. Or you may not even ever see a jury because some things may never get in.
So there's a strategic aspect to what you're doing.
Absolutely. There is a strategic aspect, and you follow that through the case. And you have to monitor these things to make sure that even if you're okay 1 minute, that you stay okay throughout discovery, and that you're building the record so when you have to argue before your honor, we have the necessary support to make sure that we either succeed on a motion to eliminate or we defeat them.
And how about timing? I mean, are you bringing all these right before trial? Is there any time that you consider a different time for the motions in limine? You want to attack something early on? Is there anything you're going to do that's going to shape the discovery, or is this all reserved for pretrial?
No, at certain times there may be a strategic benefit to actually provoking the discussion of a motion in limine from the other side. And such as if the plaintiff's deposition was not thoroughly taken, and now you have certain information that you know the defense doesn't have and you weren't obligated to give through discovery, be it interrogatories, requests for production, or something else. But you know that that information would be critical to eliminating the risk of a trial and getting the necessary result for the client. So you may do things such as packaging a client affidavit, and then you submit it in some sort of way that starts the conversation, and now all of a sudden you have a conversation with the defense attorney who's planning on filing a motion in limine, and you can tell them, listen, don't put me in a corner as to arguing this motion, because if I have to go on record and say why this wasn't developed, and it may not look good for you.
Judge, do you have anything to add into that?
I'm sorry.
You want to add anything to that?
No, I just listened in. That was really fascinating. That's a really brilliant strategy. I think some lawyers don't spend enough time on the motions for limine. And they said, here they are in Texas. We handle them pre-trial. So here they are. And you got to go through each one of them. But to have a strategy, what you just said, I think is so important. And it works.
It does.
And I can tell just listening to you, you're extremely prepared when you go to trial.
And I'm sorry, I didn't mean to.
No, go ahead.
But also, you said earlier about rotation in the
Right.
jurisdictions that you're in. In Jersey, they shuffle judges around all the time, so they don't necessarily live with the case.
Yeah.
So in order for you to educate the judge, they may be new to the bench, they may be new to civil side versus criminal or whatever, and if you have the opportunity to start talking about your case and you can be the authority on it,
Right.
then you tend to be reliable throughout the case, especially if you're more prepared than the other side. And I think a lot of times with people that practice and practice for many years, you tend to assume that you know the rules, you know the law, and you're just regurgitating the same thing. But what I do is I actually take a manila folder and write out everything. So I'm not following through papers. I'm not just citing things. I'm able to actually show the judge that I know, and I'm able to cite line and verse so he has something to hang his hat on.
Right.
And also, simultaneously, I'm able to give the judge, if I'm nimble enough, analogies to other things to support maybe a way that he wasn't thinking that would support me. Now, I think a lot of times, like the game of Monopoly. Everybody's familiar with the game of Monopoly, right? How many people actually like playing the game of Monopoly?
I love it.
Right. So most people don't like it because it's what?
Takes too long.
Right. That's because no one read the rules. If you actually read the rules, the game takes an hour to an hour and a half. Rule number 4, if you land on a property, it immediately goes up for auction if that person doesn't buy it.
Yeah.
So, Your Honor, if you have $26 and I have $50, I land on Boardwalk. I don't want to buy it for $500. You can't afford it. I bid $26. Now I have Boardwalk. The game's over in about an hour. But that's part of the assumption that people make,
Yeah.
that, okay, I know it and just regurgitate it, when you really have to go back and relearn it for every case.
Very well said.
Great advice. Know the rules. Interesting to me because I did not know that rule. So talk to me a little bit about the possibility of using motions in limine. No better way to say it, I guess, than you go in thinking you're probably going to lose, but you're going to use it to educate the judge on an issue.
Sure. What you have to do is I try to be judicious about it, where sometimes you start seeing these motions in limine are just silly.
Yeah.
And I think that the judge starts losing respect and you start losing credibility. But I think if you're able to package it in a way that you're able to talk about the case and maybe even sway him or alert him to other things, you may even get the judge to sort of reserve decision on it until certain evidentiary things are developed. But at least the judge has an idea of where you're going, and you sort of repeat your themes throughout, and it's almost, the judges are human too. We all hear jingles, we all hear these things out there, and we find them resonating in our minds. Where if you're able to do that with the judge and have that credibility and authority through everything else that we've just talked about, then you're more likely to still have that recurring theme throughout.
So I know I'm tired because I think I earlier called them motion in limines as opposed to motions in limine. Been reflecting on that. But Judge, how do you react to that last point? In other words, somebody brings a questionable motion, let's say it's colorable, but there's a pretty good chance they're using it to educate you. Offensive to you in any way? And I'm not talking about the ones that are clearly a waste of time. Something that's on the line, but you can tell they're really just trying to get you familiar with an issue for later.
Yeah, and when I was on the bench, I don't find any argument that a lawyer makes offensive. They have, our rules say you got to be zealous. We have to represent our clients. So if it's within the rules, yeah, let's hear it. But what you said, knowing the rules, is so important. I still practice. I practice all over the state and sometimes out of state. And so being a former Supreme Court justice, I think judges and justices expect more from me. So you get extra prepared. And it's really surprising how many lawyers on the other side don't know the rules because they've been practicing for 30 years, 20 years, whatever it is, and sometimes rules change. When I was a young trial judge, there was a lawyer, very well-respected lawyer, tried to get something in, and I ruled against him. And he said, well, rule so-and-so says I get it in. And I said, well, when was the last time you looked at the rules? I opened the book. I said, that rule doesn't exist anymore, counselor. So I'm going. But, know the rules, and you build credibility, and the judge, all right, this guy knows rules, this lawyer knows the rules, it's not going to mislead me, very persuasive. So when it's, hard to make a decision, you're going to get that benefit of the doubt because you have great credibility. And if something is not in your favor, you got to tell the judge, well, And I concede that rule doesn't help me, and so I concede that one. Let's go to the next one. So well said.
Excellent. So it's always considered a little bit safer for a judge, and I want you to comment on this too, to let a piece of evidence in and then either rule on it later on, or it just feels more appeal-proof that way than ruling it out at the get-go. We've encountered that several times. So I'm wondering, A, have you encountered that on something you really think should be out, but you can tell the judge is hedging a little bit to let it in and then make the decision later? And if so, how do you deal with that? In other words, a judge is trying to take the safe road, make it a little more appeal-proof. You exclude something, it's guaranteed to be an appeal issue. If you hear the evidence and then rule on weight or something like that, probably a little better to withstand the appeal.
The most immediate thing that comes to my mind on that is actually the reverse scenario, where it was a horrific death in a steel mill case where the gentleman fell into basically a trough that was filled with boiling water and molten metal, and had to pull himself out and left the skin and everything else. And it happened on Valentine's Day, so there was all these themes to go with that. But he was seen from the crane operator inside the steel mill coming out in a ball of steam. And we eventually had gotten the photos from the burn hospital. And the judge, we fought a motion to keep them out. And the judge let them in, or the judge was going to let them in. Now, we hadn't used them, and we stepped back and we thought, geez, do we really want to add this? Do we need to? Do we need to? So then we declined to actually introduce them, because we felt that the judge was letting us just try our case and, hey, you guys want to have a street fight? Go ahead, have a street fight. And then we felt like, why give them the additional appellate issue that we may ultimately not prevail on later on? Yeah. And we felt that that wasn't right for that widow or those two kids.
That makes sense. Judge?
That's very smart. I mean, sometimes you can win the battle and lose the war, and you get a great verdict and go on appeal. Well, there's no way you pick a report, an expert report, shouldn't have come in, shouldn't have come out, and you got to do it all again, do it over again, and you're doing a disservice to your client. So those are the hard decisions to make, as we know, those of us who try cases. And so not only are you trying to win this battle right here, you've got to protect that record for an appeal and maybe an appeal after that. And in Texas, you have an automatic right to appeal to the appellate court, but the Texas Supreme Court is a court of discretion. So very, very significant, very good comment on that.
So probably our final question, I don't know what your practice is like. I know a little bit about it, but generally you run into cases that the one before us today is at some level a pretty straightforward breach of contract case, kind of a he said, she said fact pattern with a lot of color around it. But there are obviously much more complex cases that you deal with too. So any difference in your approach, motions to eliminate for, call it the simple versus the complex case?
Sure. I mean, I think that the difference between the two are in the words. What you see is there's a direct proportionality of increase of the types of motions, the complexity of the motions, and the significance of the motions. I'll go back to the original example of the benzene case, where you have an epidemiologist, a toxicologist, industrial hygienist, you have an occupational medicine doctor, you have somebody for specific causation, general causation, all to show that somebody had a manifestation of exposure in what's called parts per million years.
Right.
That could lead to the disease. So each one of those experts are subject to their own motion in limine. And that, if any one of them is vulnerable, then you have some real problems on your hands, because you may not be able to meet your proofs. Now, usually with regard to, so they both come back down to, can you win? All right, that's the essential question that answers both of those.
Without or with,
right,
without the evidence.
Simple or big, right? So the magnitude may be the same for either scenario, but the level, the number, and the complexity usually is driven by the straightforwardness or, not to be redundant, complexity of the case. Did I answer that?
I think you did.
Okay.
Judge, anything to add there?
No, that was very good. I mean, it's one of the best explanations I've heard in all my practice on how motions in limine should be addressed. So, thank you.
Thank you.
All right, I think we're wrapping up right now. I want to thank you, Brian. Hopefully people found that informative. And again, I encourage you to talk to him. I got some real insight on his approach to early resolution. Like I said last night, I'm repeating myself, but it was very interesting to get a different perspective on essentially what he told me is he recently had a case that had the other side come to the table earlier, it would have been worth much less. I'm paraphrasing.
Sure.
Because
Yes.
once he got to develop a full record, his case just got much better. So it's something you got to think about.
Thank you. And I would also add, just briefly, is that if you have the ability through like MAGNA with their tech support, and when we use them for the not just trial presentation, but also just to put the super depths together, we find it helpful that if we're able to bring those types of things over before a judge, to have this visual support in our argument, that it goes a lot further.
Yep.
So we always take advantage of those services as well.
Thank you, Judge, and thank you, Brian.